Welcome back, everybody. Our last submitter for today is Mr. Sintes. Welcome, sir, and you brought along your mic. So welcome to you both. We'll hand it over to you. You've got a bit of information from you.
Because we have a leg problem, if you don't mind us.
Oh, you please sit. I mean, everyone, we're all sitting.
I'm very much being guided based on our previous communication guided us to how you want me to handle a submission. Reading it out will take half an hour at least and bore you to tears. So it's up to you to direct what you'd like.
Well, what I want to do is I want to address a couple of matters first. I've received your letter. There was a letter you addressed to me, and you raised an issue of misconduct. I've looked at that very, very carefully, and I've come to the conclusion that I don't think there has been misconduct, but I understand the concerns that you raised. But I'd like to leave that matter there. What I really want to hear from you today is your submission on the zoning of your land. So, and I know we all have this bundle of information, and what I would possibly ask you to focus on, well, what I will ask you to focus on is, I want to hear about what you want your land to be zoned, reasons why. I'm sorry, you're not hearing me?
Yes, I'm hearing.
Oh, okay. So what we're really interested in is what zoning you would like for your land and the reasons why. So if you want to guide us through those parts of the information that you've got, then
Makes it a lot easier.
yeah, I think so too. I think what we want to do is really, really focus on the merits of the submission.
The reason that the submission is constructed in the way it is because it is such a rule-based decision that it doesn't allow for practical outcomes. I've said that out fairly clearly in this report. I'm very mindful of the fact I've had to repeat more than once comments surrounding a rule-based system of land use evaluation. And I'm not going to bore you with repeating those again. It's contained in the report. The fact of the matter is we've owned the land for many, many years. Our children grew up there, and it's so ingrained in our children that even today, even though one daughter's in Western Australia and others are legal practice in St Heliers, they still refer back to Kerikeri as the foundation of their family. And I want to leave. I was diagnosed with incurable peripheral neuropathy. Now that's my problem. I don't want to get engaged with that. I want to leave the land use for my daughters in a way that doesn't have them the processes of zoning or land use after I'm dead. So my desire to see an appropriate zoning for the land is not driven by profit. It's not driven by some pecuniary interest. It's driven by a need to finally see an appropriate zoning of the land. The land, as you know from the report I've submitted and from what's on the web, my original support, which was very detailed and is now online, is the land is deemed unproductive, surrounded by residential gardens. It is simply miszoned, and I appreciate Melissa Pearson's comment surrounding it not being zoned for horticultural production, but zoned and left as it is. Unfortunately, leaving it as it is a non-event if it doesn't produce any outcome. My entire life has been driven by its outcomes. One of the questions I wish to raise to demonstrate a wider point is what the zoning is for the 10-acre block directly behind us. And this will lead to very valuable lessons for the commissioners. I wondered if that's because the plans are unreadable when you look online. Can you tell me what the site directly behind us is zoned at?
Sorry. So you're asking me
No.
to ask Ms. Pearson.
Yes, thank you.
If everything comes through the chair, right? So we don't allow any of this to happen. So you're asking me to ask Ms. Pearson.
Yes.
It's funny you say that because I was thinking exactly the same thing. So when you say behind, you mean to the north?
Directly north of us.
So Ms. Pearson, are you able to, I can't get the planning maps going, otherwise I would have answered the question already.
I'm only raising.
So Ms. Pearson, are you able to tell us what the zoning directly to the north of Mr. Sinter's site is?
I'm just double checking to make sure.
And why have you got the maps working immediately?
I had them loaded last night and they have stayed zoned, thank goodness. As notified, the land directly to the north of 1998 Wedo Road was zoned horticulture zone, which is the same as the two properties that Mr. Centers has got subject to submission. They were all horticulture zone.
And is it recommended that the horticulture zone remain on that land?
On that land to the north, just check Appendix 6 of my report. There is land immediately to the north that has also been pulled out of the horticulture, what is now being recommended to be the horticulture precinct.
Okay, so identical in terms of, so Mr. Sinters, the answer to your question is your land was notified as the horticulture zone. The land adjoining you to the north was notified as horticulture zone. The council, as a result of hearing 9, has converted the horticulture zone to a horticulture precinct. It has recommended the removal of the horticulture precinct, the new horticulture precinct, from your property and the property to the north, but that they both retain a rural production zone. That's correct, Ms. Pearson?
Okay, that's fine. I'm happy to provide a background to that question very briefly, but it's not relevant now. It's basically the land behind us, as it was originally intended to be zoned, is actually a lake. So how that could ever provide the initial horticultural production zone is one of the issues I raise in a wider canvas, because you can't look at land zoning, this is my primary submission, without actually having an on-the-ground valuation of what's going on around it. And with the greatest possible respect for Melissa, who's a very polite client to me, I raised repeatedly in my fact that the rule-based decision-making process is not appropriate for existing long-standing development. That's one of the things that confronted me in constructing this report. Yes, there was repetition, but there had to be, because each and every claim by the land in the report on that was to the effect that it didn't meet a certain set of rules. Unfortunately, rules have to be applied sensibly and realistically, and in this case weren't. And that, I'm not going to lie about it, was a point of frustration, my wife and I, because we lived on there for a third of a lifetime, and we knew exactly what the land wasn't capable of and what it should be. So I can go through chapter and verse in this report about certain contradictions which emerge repeatedly throughout the report. And to the extent you may or may not have currently read my book, because you're very busy and I'm sure you were tired last night.
Well, I have read the evidence that you provided.
You have,
You have.
Well, thank you. For that reason, I'm mindful of being practical about making a submission here, really, because it seems to me that.
So what I think the panel would be assisted is for you to outline and summarise to us why you think it should have an alternative zoning. I understand it's rural residential.
That's the request.
So what I'd like to hear from you is why you think your land should be zoned rural residential and not construction.
One of the challenges is that the existing rural production zone has been on this area Weaver Road, the full length of Weaver Road for some considerable period. It failed. It was never properly addressed in terms of an appropriate zone. And what occurred was there was a migration of development, commercial, a lot of residential, as you can see in the plan that I provided, which altered the nature of the land itself. In my report too. In my report too, I pointed out that in fact this was really a special purpose. It's like a feeder road to an airport. It's got, I've listed some of the things that are there. I've missed a lot because I'm doing that memory in Auckland. But the truth of the matter is, it's no longer rural production. It is in fact predominantly residential housing with some industrial plants, some airport related works, and to apply a desired rule which was predicated on a natural progression of land development which you could control didn't work because it was there, it existed. And so my concern is to treat the land and the use of the land on the basis of what it is and what it can be successfully and appropriately used. That was rural residential. You know, we're surrounded by houses, they're all on the same size lots. With respect to the owner of 90 Weaver Road, who inappropriately managed to gain submissions into these proceedings by a backdoor method. It's interesting to know that this particular person lives on a lot subdivided by my wife and I of exactly 1 acre, exactly the size. Plan that says it's not an appropriate size for the area. I don't know. That's why I produced the plan. This plan shows where all those small site developments are. I didn't make up the plan. It's there, it exists, and I've colour coded for the commission. There. So then address, well, what you know, I'm a realist. What do you do with land that is deemed unproductive, surrounded by houses? That's the real question. That's the coal-based question. And do you just abandon it and say, oh, I'll leave it where it is? That's not an answer. That's not an outcome. That's an abandonment of an outcome. What we need to do is what is the best use for this land? That's why we ask for rural residential. And I pointed out, for example, that through the entire process, which was heavily publicly notified, not one of my neighbours who previously all signed to agree with the original subdivision has objected in these proceedings, except for the unfortunate, inappropriate impact the owner of 90B, who currently lives on land that I created for her, exactly what I have, and now doesn't want my neighbours sites beside her. Maybe because she grazed a horse there for a long time with nothing. I'm not going to go road because that's an English road. Comment that really isn't that factor. But the reality is when we read this report carefully, there was a corruption of process there that was offensive to my wife and I. There are discretionary provisions for commissioners to accept evidence or reject it. And that's actually your choice. I accept that. But it is for me defamatory, and that is a matter that I will be thinking privately. It's not relevant to these proceedings. Thank you. But you can be sure I will do something about it.
Yeah, that's your prerogative.
Sure.
Yeah. But as I said, we're really interested in the merits of why you want your land.
So I can go through, as I've included in this report, referencing various matters. But I can give you one example of where this probably was actually which pages. You know, in page 28 of my report, it says at the bottom of that page, page 21. I'm desperately trying not to be unkind here because that's not my intention. But the planner says the officer will consider consistency of Kerikeri-Waipapa Spatial Plan when evaluating rezoning submissions for areas of FNDC. I don't know why that was in the report, because the planner at the end of the report is recommending the removal of the zoning, the intended zoning. So almost like it was printed by artificial intelligence, if you'll give a very polite expression. I mean, I'd like to try and explain something like why the campus schedule. I used to run New Zealand company, Sanyo Television. I was at a directors meeting in that meeting where one of them, as a young man, gone on rather rigidly about what I thought should be done. I was taken aside by company secretary, a man called Cliff Reed. He said, Rob, many shades of grey between black and white. And I never forgot the advice that very intelligent man gave me. And the problem with this, the planner's report is it totally ignores, not only does it fail to address any shades of grey. It's strictly, oh, that doesn't mean that rule, so that's the end of it. That's precisely what this proposed district plan was designed to remedy. And the report did not do that. It's worse than that, because the reports that were written on a wider campus, which I very carefully read, all reject all these sorts of these submissions. I refuse to believe that we're wrong. The fact that we're not really wrong. And if I could have, I desperately sought to have a site visit. A site visit is not driving by in a car. You have to visit these sites. You have to understand the dynamics of what's going on in these many communities. This is just not enough to drive. And I was frustrated by the declaration of a site visit had taken place. A site visit never took place. I almost begged for it in a series of emails that I can produce, and I was turned down. I then, as you can see from the attached documents, asked the planner if she would identify whether she'd actually gone onto the site and spoken to the neighbour or anything else. And the answer, as you can see in the documents I provided, said, no, I can drop by. Now, I don't know how you can effectively plan for outcomes that my wife and I seek in those circumstances. And this is not a personal criticism at all.
Okay, so Mr. Sinters, would you like the panel to visit your site?
I'd like the panel to be given the opportunity to understand the nature of this, the substance of the submission we've made. And I think it is possible for you to make an arbitrary decision without doing any site visits. But I would suggest to you, that a site visit is the most appropriate thing to do.
Okay, well, I think we have some time in this hearing this week, and we have some time tomorrow afternoon and Thursday afternoon.
Yes.
So we'll give you an undertaking that we will come and visit your site.
Yeah.
Either Wednesday or Thursday. We need to have a chat as to which day is best, because we're going to visit a number of sites. And there are a number of sites that we have decided we are going to visit. We were intending to visit your site. What we'll do is give you the undertaking today that we will come and visit your site, and if you can take us around the site and point to things and show us the things you want to show us. I will remind you though, is that you won't be able to provide any further evidence to us. You won't be able to say, that's why I want this, that's why I think this is wrong. And it will be, I want you to see this, you to see this, and I want you to see this, and I'm happy to do that.
Yes, because
But here's the thing.
the thing is,
I've driven that road countless times, and I must say, I go to the airport and back again a lot. But I've never. I sort of broadly understand that road, but you're quite right. You would need to get hold of the property to fully understand what's going on. So we have to do that. But what we would also do is refresh ourselves with the context of what is also in the locality.
yes,
The other rural residential sites that are there, where the horticulture is and where it isn't, the proximity to the airport, all those things.
that was particularly detailed in my second report when the ME consulting report came out. I wanted to address that, and that's what I had added to our original report, which is down the line, which is full of the detail. The second report, because it seemed to me that I think it's ME consulting, but you could easily correct me on that, pointed out true position, in terms of land demand in England. And I'm happy to receive comment from your plan, but I struggle to see how. Let me go back. When I went down to the preliminary meetings prior to filing a submission, there were preliminary meetings in the centre of Kerikeri, where you could discuss the plan, which you saw, but it was all not recorded, it was just an advisory meeting. It was way before the spatial plan meeting. It was at the very beginning of this process. And I asked the senior planner, we had a discussion with, how she determined what should be horticultural production and what shouldn't. I said, did you visit any sites? Did you conduct any soil tests? Did you talk to any owners? And the reply I got was no, it was far too busy for that, because the pencil line ran around. That, in my view, was totally inappropriate approach. Planner in question then asked for the soil scientist report I had. I refused to give it to him because it was being used for the original subdivision and was accepted by the council and approved by the council. So, yes, I'm disturbed at the way these things have been handled. Because if this process that we're discussing now is to be based strictly on a rule-based analysis, then you might as well tear the whole of it and chuck it away. That's the problem. So, because the rule-based analysis does not address, neither does table 6 address, as I detailed in this report, it doesn't actually address alternative land uses at all. It simply makes it blank. Well, a maybe result, a colour-coded result. And table 6 really needs modifying. Be fair, included in the section 42A is an exact statement to that effect. Well, this is a preliminary way of evaluating that. My word, it's not a report. Simply, because I referenced it, the page and every how you can find it in the 42A. So I accept that, and I'm very grateful for that. But as it's currently applied by the plan, it's corrupting sensible land use outcomes. That's the problem. And my repetition of that in this report is designed to highlight that point. And, and that's one of the reasons why I don't want to, if you've already read it, I don't want to read it out because it'll bore you to tears.
Perhaps you could help me with, can you tell me the size of your property? What size is it?
Well, there's a little bit of history there, and I'll give you a precise answer, but when we finally got a plan, we had by then sold the front lot, that's number 90. And I had assumed that 90, because it was included in our original submission for a correct rezoning outcome, that it would still be there. But after the property was sold, and there may be very serious reasons why my application then did not apply to number 90. I realised that number 19 had been excluded from the rezoning application. So I then contacted council and said, hang on a minute, my application is for 1998. And he said, well, it's sold. I said, well, it should be reinstated. I then went and saw, because I'd already given the owner the purchase of number 90, an undertaking that I would, if he wished it, include in my submissions his lot of land as was originally intended in my original submission before the land was sold. I went back to him and said, do you want to do this? He actually wrote to council, said, yes, we want to include it, and give council full credit. They then included it in the submission. So so to answer your question, it's 10 or 11 acres. But how it arrived at that was a convoluted route because somebody took it out of the hearing process and then put it back again. I don't know if that fully answers your question.
Can I ask a question?
Sure. Go for it.
Thank you. Thank you for your evidence. The question I had, you've asked for rural residential. There are other zones such as like rural lifestyle, as well as, you know, what the other general rural zone. So why rural residential? Why not rural lifestyle? And given the reverse, given that's next to an airport, why do you think that those types of activities are suitable for regionally significant infrastructure like an airport?
Well, because I trained as a police pilot, and I actually, one of the first things I did is I went to the airport because it's right on the cusp of the airport zone. And as you can see in my report, which is the actual document is included as submission 1, which is online. The airport authority said, no, this is not a problem. I've included the actual words in the report you've got there. Unless you look at it on the letter, which is the first report, this just hearsay. But it is there in the original report. So there is no conflict. There might be functional matters like should the house be double days? But there are no other issues. And one of the reasons for that is twofold. Grass runway, the small grass runway is functional, but largely only used for an access way through to the central runway and to the grass strip to the east of the central runway. That is the reason we do that is for safety. If you're getting into a microlide, you're trained in something about microlide. If you have an engine failure, you've got time to get down again because of the length of the runway. And so there are no issues there. It is an issue raised by the owner of 90B after the first submission was rejected because it was defamatory. And they cancelled it for their credit, refused to put it in the formal record. What happened then was that somebody, it clearly wasn't 90B, although I have no proof of that, then rewrote it. First defamatory report by the owner of 90B said there were petty hills in Kiwi. There are no Kiwi there. We had dogs for 30 years, and if there was any Kiwi there, the long since eaten them. But there were never any Kiwi. So then she's migrated to a second submission, which currently you're willing to accept, which is that aeroplanes fly overhead and aircraft from Kaitaia. Now, on 500 hours of flying, I can assure you that if you're on the ground, you wouldn't know where the hell the aeroplane came from. Neither would I, because I have access to flight plans, and sometimes flight plans aren't lodged. So these claims are nonsense, but I'm reluctant to go down there because it's addressing things appropriate. But to answer your question, the airport has zero effect on the usability of the land as included in the airport manager's report for the first subdivision. That's
My question was about, rural residential zone versus rural lifestyle zone.
Sure, the answer to that is that the surrounding sites, including the overlay, is 4,000 square metres. Sites around it, which are highlighted in the plan that I've provided, are relatively small lots, and the flexibility of rural residential allows for a multiplicity of sites based on ground soakage, desirability, access, and all the other consent-related conditions. Now, may well be that ultimately I would elect to, let me qualify this, I have no desire to subdivide the land immediately at all. It's to leave a heritage showing that my daughters can use to separate the property out of settlement estate, or when the settlement of their estate is occurring. I don't actually need to subdivide land, I don't need the money. I don't want to pay the rates on it either. I just need the correct zoning, that's all we're seeking. And the flexibility of rural residential is, in terms of site size, it's more amenable to the land, surrounding land. It's more amenable to the effective use of land.
So your view, your flexibility for your site or for the whole area, because we have to zone the whole district, not just your site.
No,
Yeah.
because that's one of the problems with applying fixed zone rules to individual and specific sites. It doesn't work. You have to look at the site, which is why I'm so grateful you're going to come and have a look at it. Because it's no point in applying rules that may apply to our site to somebody else's site. Maybe appropriate, maybe not. It's not precedent setting. Is that satisfactory answer to the question? Because I really want to.
It's just that the site was so special. We had special zones like Goldie Cliffs and Carrington Estate and Giant, special zones, regionally significant.
Yeah.
And they had special zones.
Yeah, one of the problems is that
Sounds good.
when you
Rural residential.
when you apply regionally specific issues, small lots of infill land that are shrank by out the average really problem. Because you have to talk of migrating, fragmentation, none of which exists. Isn't existing in this particular situation. So you can quote it as long as you like, but it isn't there, it doesn't exist.
How many houses are you looking at rezoning? How many properties?
Well, that was one of the problems, because I could say that the permitted use is 4,000 square metres or bigger, but I don't want really 5 sites there. I don't want any sites there, really. I want the appropriate zoning to occur because I'm too close to the wrong end of life here. If the zoning is correct, it could be 5,000 square metre sites, which would be a perfect distribution of the available land. It could be 4,000 square metre sites, but I don't think that actually is viable. It just depends on, and this is where you migrate out of a planning consideration through to consenting consideration. The consenting consideration is addressable those matters, and it may not say no, possible. So, but you need a bit more land, which basically 5,000 square metre. And those things are normally handled at the consenting stage. My aspiration is very simple. Before I pass my draw up the plan, for the best use of the land, and then hand it to my daughters and say, at the appropriate time, you should do this. That's all I want.
So could that be done by way of a consent application without a rezoning? I mean, if you're looking at a lesser number of properties.
Well, as I've included in my report, what that does is leave for a second hearing 3 years later, which could easily have been addressed here by appropriate zoning. And leaving people, families like ours, faced with fragmentation. Is it fitting the plan? All the rules that are identified here don't relate to a practical application of use of that land. We'd be doing it all again. And that's one of the problems with leaving it as raw production. we're faced with another 3 years. It's an endless circular process unless the commissioners take the opportunity to give it its correct zone. And that doesn't mean to say, I mean, we're not interested in selling the land. We've owned it for 30 years. I'm all my children. It's got a very close connection with Kerikeri. Share it equally, but I have 2 daughters. If you think you can get 2 daughters to share things equally without putting it in the place before you die, you're living on another planet, different realities.
It's normally the in-laws that are the problem, not the children. It's normally not your children that are, maybe it's personal experience. It's not your children that are the problem, it's the in-laws, it's the people they marry.
I had a stroke 4 years ago. And the neurologist Barry Snow in Auckland said to me, I said, Pal, what do I do? Very unfortunate circumstance. And he said, put your affairs in order. The fact that I've lasted another 3 or 4 years is a bit of a miracle, certainly in fact my ability to think. But the point is, I'm trying to put our affairs in order. That's what a good parent does. And an appropriate zoning for the land as rural production is the correct outcome. It's been interrupted by a strictly rule-based approach, as you can see in the planners report, which bears no connection with the reality, the on-ground realities, which I defined in the definitions in the back of my report. On-ground reality of what actually exists. I was very mindful of the book. This is going to sound a little bit hesitant to say it, but if I could, I tried to take my daughters to one side, as in the development years, tell them that there are many shades of grey between black and white. And my daughter's generation, since I believe it's the young people here's generation, they don't understand the principle precedent for many shades of grey. You can't plan the way the plan of submission is written. It's too rigid. It doesn't work. All the applications were rejected. That's getting off track for them.
Well, I have the same issue I've mentioned several times today. I've known Robert and Sue for a number of years. It was interesting to see this because I was valuing in 1986. We had to deal with the Bay of Islands County Council. But in your document, there's 2 things that I think will be useful if when we get the opportunity to come and see, and that's what you've provided there, which is all the, what you say, 69 homes and 18 various sorts of commercial properties over 2.1 kilometres. So it gives some concept to it. But the part I wanted to ask you, I probably know the answer because I was here, but you say on page 30 of your submission, historical overview, the old Bay of Islands County Council May 1986 preview statement of 39 years ago issued the issues surrounding rural residential land use and subdivision largely mirror the same objectives sought today. And that, as I understand, I just want a yes or no, really. Your objective is to get residentials of rural residential so that you can have the opportunity to subdivide at some stage in the future.
Yeah,
That's the answer?
I understand that. Nothing had changed.
No. So if we get the opportunity either tomorrow or the following day to come and have a look, I can point out to my fellow commissioners.
Yeah.
And then there are some other parts within our section 42 banner. Ms. Pearson, she's identified a number of issues. One of them is that rural residential would allow 5 lots per the 2 hectare sites, so there'd be 10 lot subdivision. So then the question is, what do we do about the transport addition? We are road.
I can understand. Because of, they haven't, it was very hard to make a submission of both lots because they had to treat or address the primary rules that have been applied in the planners report. There's also a question of how many sites could actually be achieved on number 90, and there's not very many because of the nature of the soakish tiles put in by Mike Leeward and I many years ago. Is question of geography there.
Yeah.
But would allow 1 or 2 sites maybe, but that's fine because neither he or I want subdividing. Both the owner of the front property is Ross and Kenny. William, lovely couple. They have a lot of horses, as we did through the many years we spent with our horses on that land. Yes, he just wants the underlying zoning to be correct. He has no interest in chopping the land up and selling it. He's a multi-millionaire. He's owns farms over the place. He just wants to keep doing what he's doing until he can't anymore, but leave the correct underlying zoning in his estate. Pretty much what we want.
Yeah, but the commissioner's role is we have to look at that long term, what's the outcome down the track and what's the
Very
consequence.
few extra sites above what the maximum is on our 90A would be, because he cannot emulate what we could achieve on the back if we wanted to. I don't. He can't because of where the house is, how the land is laid, in terms of its geography.
Yeah, that's helpful. And I'm allow us the opportunity to have a look. I know it, but allow them to have a look. And then they will know it also.
I
System making a decision.
I'd be profoundly grateful if you want any questions. So I'll attempt to answer.
Yeah, well, what we'll do is, we'll have our hearing administrator, AK, who you met, I think, on a number of occasions. She'll get in contact with you to let you know, what day it is that we would like to. It'll either be Wednesday afternoon, tomorrow afternoon, or Thursday afternoon. We can't quite put a finger on that date yet.
I'm here till Friday.
Yeah, fine. So are we. Alicia Kay will be in touch with you to let you know when, what day we'll be visiting, and at what time. You can then confirm with her that that's okay, and then we'll make it happen.
There's a very big entrance to this property, as defined in my submission. If you drive down the drive, I guess in one drive, and you come in, the nothing's going to drive onto the, because it's a bit of a walk down the drive.
Okay. Well, we'll probably be arriving in 2 vehicles because we're all staying in accommodation.
Yeah.
Of course, Commissioner McDonald's own house here, and so we'll probably be 2 vehicles, and I think we'll do it. Okay. Well, thank you very much for your submission and evidence, and we'll be in touch shortly about your property. Thank you.
Thanks again.
Thank you. Have a safe travel home.
Well, we're saying we live in Auckland and live there.
Oh, all right. Another Auckland here.
Thank you.
Yeah, thank you very much. Right, I think that's look, I'm not going to ask the council officers to respond to this. I think we'll just wrap this up when it comes to the time.
Thank you, Mr. Chair.
I think we'll just bring it to close.
Sure. Protest with a karakia. Turuki whakataha, whakaere, te wānanga, kia wātia, aira, kua wātia, huie tāki. Thank you. I will stop the recording.